Okay, so just carrying on, one thing I'm just going to mention is that what is not a trust, what you can't do, is have one single person who is the trustee and only trustee and the only beneficiary of an asset. Yeah, because that is recognised as not being a trust. Now, I put this up here because apparently there was somebody for some time who was basically selling these sorts of trust deeds in Auckland for a while. So it's not a trust, that's just absolute ownership. So you absolutely have to have this separation. What can you put into a trust? Anything that can be owned. So anything that we consider to be property can be put into a trust. I think we've gone through this. Fixed interest is something invaluable, so we don't need to do that. Now, the other thing that we have, just to sum things up, is the rule in Saunders and Vautier, which is a rule that in English law and in our law that says that if all the beneficiaries, so everybody who's absolutely entitled in equity, gets together and decides that they want to terminate the trust or collapse the trust, then they can do it. They've got to be sui juris, they've got to be of age and of sound mind, which in New Zealand at the moment is 20, but I think the idea is to drop it down to 18. Now that operates certainly for domestic trusts. It can apply to commercial trusts, but there's a restriction because it can't if it undermines the fundamental purpose for the transaction. Okay? Now that's quite undeveloped. You don't. There's not much case law on commercial trusts, but you can imagine if you had, you can get quite complicated situations, say in a pension fund where you've got some people who are entitled to receive a pension, then you've got a whole mass of people who aren't. So the idea is, well, that just the pensioners who are receiving can't get together and terminate the trust and have everything collapse. So you need to have different sorts of restrictions when they're used in commercial, but it just hasn't really come up, so we don't have much case law.
Saunders and Vautier rule.
Yep. Oh, go back.
I heard someone say the other day, where's the discretionary trust and the beneficiaries are, the settlor or the settler's children, any remoter issue?
Yes.
And then the question came up is, well, when can it actually be exercised? The settlor's got a couple of kids, and grandkids, and they're all over 20. Can it be exercised?
No.
But the argument was, no, if any of the beneficiaries is of a childbearing age and could produce an offspring, then you haven't fulfilled.
Yeah, that's right.
Fulfilled that.
Yeah, I think you've got. The rule is a bit more developed in this. So if you've got particular interests, you can hive off particular interests, and certain people can come out of trusts. So I haven't gone into that case law, but again, you just have to look at the cases. If you can take it away without affecting the other beneficiaries, you can. There's a bit more of a sophistication in this than I put up there. Well, but I would have thought not if you've just got a general,
well,
if you're looking to collapse the whole thing. It's got to be everybody entitled in equity, everybody sui juris who gets together and decides. And if you don't have that, you can't use the rule.
Yeah. So while it sounds like, that rule can be readily used, it's actually very difficult to use it.
Yes, it's not often used. Yeah. Not in the way we use trusts now. It's probably more useful sort of in the past. So we've looked at, we don't need to go into resulting in constructive trusts anymore, but I'll just leave you with this lovely quote. This is Frederick Maitland, who he's a famous equity jurist and Downing professor at University of Cambridge. He died young. I think he died in about 1904. He's a very interesting chap. He used to correspond with all sorts of, people around the world, and particularly some of the American jurists and Supreme Court justices. So you can read books of the letters they wrote to each other, which are rather interesting. Anyway, he's made this comment: the idea of a trust is so familiar to us that we never wonder at it. And what he went on to say is that he thinks that the development of the trust is the greatest achievement of Englishman, because it was then, in the field of jurisprudence. So he would say this is the greatest thing our common law system has ever created. And I think that's true. I do, Certainly, I suppose you could look at the contract and say that is another great achievement. But I think what the trust has over a contract and over the common law is just the flexibility and the things you can do with it together with the protections, that it's to make it so useful.
And it's the way in which it develops and
Yeah.
keeps on developing, like contract or like the corporate veil, none of those things keep developing. They're kind of fixed, aren't they?
Yes. So one of the things that is really interesting, and one of the problems I think that there is with the Law Commission and this plan to put duties and the characteristics of a trust into statutory form, is that creates a sort of a code. So it's like a civil law jurisdiction. Civil law is often put into codes and it becomes very restricted and limited. And you look back in history and say, well, look, you know, we don't use civil law, normally civil law devices in commerce because we've got better ones at common law in our legal system. And that's a big problem. So one of the things, just so you know, this is why I'm really against putting things into a trust bill. One of the things that's happening in equity is that the courts are beginning to, through sort of commercial trust cases, look at this whole idea of what it means to hold something in trust and to say that you hold in trust for the benefit of the beneficiaries. Because that becomes difficult in relation to, well, certain types of domestic trust, but also in commercial trusts, because what you can do is by creating a trust structure and then layering powers on top of that, you can actually enable decisions to be made. So third parties, you can say to a third party, you've got the power to make a decision and direct a trustee as to what they should do. Now, if you do that, you take the decision-making power away from the trustee and you give it to somebody else. That means that you can direct the trustee, depending on the nature of the power given, you can direct the trustee to make a decision that is not in the best interests of the beneficiaries or not in the best interests of all of them. So I'll just give you an example of that. So if you've got a securitization, so you're raising money, you've got assets that are held in trust, and you've got people who've basically invested money and are receiving an income stream through sort of through interest on it. What you would typically do is have different tranches. So for investors, you'd have different tranches of types of investment. So you would have some investment that is AAA rated by the rating agencies, and that might carry 3% or 5% interest and be guaranteed by an external guarantor. So somebody will come in and say, if everything goes pear-shaped, we will repay. You'll get your money back. And then you'll have, and sometimes you can have up to 10 layers or more of different types of, interests you can buy. Normally right down the bottom of it, you will have, investors can buy sort of investments that will carry very high interest rates, but you get paid last. So you get a waterfall, they call it, of interests. And what would normally happen is institutional investors would invest because they'll be restricted in what they can invest in. They'll go into the highly rated investments because they've got, like pension funds and insurance companies and things. They'll be careful and they might invest in the levels of, that carry a guarantee. And then down the bottom, you tend to have more hedge funds who are prepared to take a risk in what they're doing. So if you have some levels that are guaranteed, then it would be common to give the guarantor the power, if things go wrong, to dictate to the trustee when the underlying assets should be sold. And often they'll just be, the underlying assets will be just obligations. But, you can sell rights to receive, if you've got a whole lot of mortgages, you get an income stream from the mortgage holders. So you have those sorts of rights. So in that sort of situation, you can have a guarantor. You can give a guarantor a power to make a decision in their own best interest. So they can say their interest will be to make sure that they're not liable under the guarantee. So normally, if things go wrong, they would be looking to say, well, look, sell as quickly as possible if we can get a price that repays us. But that might not be in the best interest of people lower down the chain, the hedge funds, who might say, no, ride out the market, because if we just sit tight for 2 or 3 years, the price is going to increase and we'll all get paid back. So you get quite difficult decision-making processes that, that can take place within complex transactions. And if you try, basically, if you try and tie everything down, this is, in a trust deed, it can be problematic. So with these commercial transactions, what some of the people are saying, there's now a couple of cases about it, is to say, well, what do the trustees have to do? Actually, they've got to act, we say they've got to act in the best interest of the beneficiaries, but often they won't, because there'll be a power of direction telling them they're not allowed to. And then say, well, how do you control matters, and what really is the trustee doing? And so the argument is, well, actually the trustee has got to carry out the trust for the purposes of the transaction or the trust. So you're changing the description really of what your trustee is doing. So that's just beginning. So the normal rules that we would teach you is to say trustees must act in good faith and hold the assets for the benefit of the beneficiaries. But that may well change, because our dominant use of trusts is for something else, and we might use other words to describe what the trustee is doing, like the trustee must exercise, hold the assets to fulfil the purpose of the transaction. So if in New Zealand, if we have got written in our Act that trustees must act for the benefit of beneficiaries, we're not going to keep up to date with what's happening, and we're destroying that lovely flexibility that has been so useful to us over centuries. So that's why I have and none of this is looked at by the Law Commission. It's a very sort of, sort of quite a narrow remit that they took. Anyway, rolling on. I still think the trust is the best thing that we've had, and that there's a number of more modern comments about that. So now I just want to move on, and we'll end that, and we'll what I want to start looking at now. Make sure I've got the right one. No, not that one. It's the three certainties. Does this come back? Yeah, okay. So what we're going to look at is the rules that determine how you can create a valid trust. So this is what we're going to look at. So when you want to get rid of an asset or pass it out of your ownership, three things you can basically do. You can gift it to somebody, which is normally a gratuitous transfer. That means a transfer without consideration coming back from the other side. You can sell it or assign it, depending on what it is, or you can create a trust. So what you're doing with all of those things is moving ownership at common law from yourself to somebody else. Now, we've gone through quite a lot of this already, so I'll only do it quickly. So one of the reasons why you use a trust, the advantage is because it gives asset partitioning, enables you to separate, but you can also keep control in a way that you can't where you gift things to other people. So the asset partitioning advantages are that you reduce risks on insolvency. So that's the Lehman Brothers case, which describes that. But so that means you can have somebody managing something, but you're not subject to the risks of their insolvency. And you've got a whole lot, if you create a trust, you've got a whole lot of general trust law rules, like your fiduciary duties and principles that regulate conduct. Okay? So it's an efficient sort of system. Now, if you want to create a valid trust, there are actually a number of things you've got to do. First of all, the settlor's got to have capacity. You've got to have mental capacity to make the trust, and then you've got to satisfy the tests for these things called the three certainties, which we'll look at. You've also got to comply with any formalities. Now, formalities are simply statutory obligations for some sort of signed writing. So some things you must have writing for. Not all forms of trust, but some forms of trust you do. And then you've got to constitute the trust, which means the trustee must hold or control a legal title to the assets. Okay, so we're going to look at these sorts of things. So the three certainties basically fit in with these questions. So where you want to create a trust, the first thing you want to think about is what actually are you intending to do? Are you intending to create a trust or a loan or a gift, or what is it you want to do? If you're going to create a trust, you've got to do it very clearly, because if you create a trust and somebody accepts the office of trustee, then multifarious duties land on their shoulders and personal liability lands on their shoulders. So what do you intend to do? We call that certainty of intention. You've got to determine what asset you're dealing with. Yeah. We call that certainty of subject matter, and you've got to determine who you're going to pass ownership to, and we call that certainty of objects or beneficiaries. So, and there are legal tests determining each of these things. So, the case that set out the three certainties is this case, well, the main one we refer to as this case of night and night, and that basically just says that you've got to use words that are imperative, and then specifically set out who's to benefit and what they're going to get. And that is law in New Zealand, in this case called Thexton and Thexton. So that was Justice Salmon, I think, made that. So what is the rule for certainty of intention? So we have a maximum in equity, that equity looks to intent rather than form. So the whole idea when you're looking for you need certainty of intention, that the settlor is intending to create a trust obligation. So the test is intention, and what you're really looking for is whether sufficient intention to create a trust has been manifested. And when you see the word manifested, what it means is you've got to show that so it can't just be an intention in your head. You've got to actually show that it exists, and normally you'll do that through some sort of evidence. There'll be some sort of evidence. They'll have signed a trust deed. Yeah? So you'll look, basically you can look at the words that are on the page of the trust deed, but that's not in itself the whole story. You sort of look around at what is happening and how people are behaving. But the test for certainty is basically what is needed is the manifestation of an intention to declare a trust. Okay, so normally we use standard words now, quite often, that will show that a settlor, somebody who signs a trust deed, the settlor is intending a trust, so we use words like upon trust or on trust. But even if you use those words, the courts can find that a trust exists, even if a trust exists without those words, and it can also find that no trust exists even though you've used those words, because they'll look at really what's going on. And just a funny old case that deals with that, just to remind you of it, is there's a case in India. I'll put it up here? Oh, no, I haven't. So it was a case called Kinloch and the Secretary of State for India. And what happened was that during Queen Victoria's days, when there were wars in India, she basically sent out a message to the army in India, and she said, "I grant booty of war to the Secretary of State for India and Council on trust for officers and men of certain forces to be distributed according to certain scales." So obviously the intention was that booty of war was going to be distributed amongst the soldiers. And an action was taken by one of the soldiers because distributions weren't made. And so he said, hang on a minute, Queen Victoria's declared a trust, and look, she's used the words on trust, and this should be coming to us. Went to court, and the court said, oh no, Queen Victoria did mean the words, did use the words on trust, but actually she didn't mean a trust relationship. In fact, she wasn't meaning that. So the Secretary of State for India is not a trustee, just a mere agent, and so you're not going to get your stuff. Basically. So even Queen Victoria might use the words. But when you're looking at words, and the way this really comes up in modern society now is when people use informal trust deeds. And we do get some of those in New Zealand. People don't want to use an expensive lawyer because you get what you pay for, don't you? I don't know, it's about $5,000 or something, $5,000 to get a decent trust deed, I would have thought. So where you get informal trusts or trusts that are poorly drafted, then that's where the case law is coming through now. But what you look for, it's sort of in the terms of the wording, you look for what are called imperative or mandatory words, shall or must, and not precatory words expressing a wish or a hope. So in the past, you've got to be careful with the cases. If you're looking at unusual wording, you don't look at cases before Lamb and Eames, because the cases before that, the courts were prepared to recognise trusts when there was much more informal wording, and that was because under the case law for wills at the time, if a will was badly drafted and you couldn't tell whether something was a trust or not, and say the trust failed, the executor of the will was entitled to the asset. So the courts bent over backwards to ensure that that didn't happen. And then statute came in and said, no, the executor of the will is not allowed to get the assets. So once that statutory protection was in place, the courts got, the test for certainty of intention became much stricter. Now, I include that in there because if the trust bill, the way it was drafted, was trying to, they've put in to the trust bill sort of the tests for certainty, but if you look at the wording of it, it's quite vague, and you would have an argument about whether this test for, I think you'd have an argument about whether the test for certainty of intention that we have now is intended to be preserved, and whether you might argue that you can go back to the tests that operated pre-Lamb and Ames, and that things that were much more informal, could actually be treated as trusts. So that's why, unsettling effect that, sort of statutory changes can bring. Okay, so the normal words, as I say, that you would use have to be imperative or mandatory. But normally, if you don't have if you have words that are more fluid, what the courts will look for in determining whether there's a trust is whether there is an indication from the settlor that if the wish or the hope isn't expressed, that a particular division takes place. And you see that through these cases, Ree Adams and Kensington Vestry and Komsky and Bowring Hanbury. So I'll just explain that to you, because this is the test that we use. So in Ree Adams and Kensington Vestry, there was a will where a husband was leaving assets to his wife. And the words he used in his will were, in full confidence that she will do what is right as to the disposal thereof between my children, either in her lifetime or by will after her decease. So in full confidence that she'll do what's right. So he left all assets. So the issue for the courts was, does that mean that this testator is leaving those assets absolutely to his wife, saying, oh, I think she'll do what's right because she's a good woman? Or is what happening is that the wife has been created a trustee and that she has a trust obligation to deal with the assets between her children? What's the obligation? So in that case, the court said, these words are not mandatory or imperative. In full confidence it basically expresses a belief. He just leaves it to her to do. So he's not making her a trustee. He's not saying she carries all the burden of trusteeship. This is an absolute gift. And all there is tacked onto it is a moral obligation. She can do what he wanted her to do, but she can also disregard it. But it's not legally enforceable as a trust. Komsky and Bowring Hanbury is a similar sort of case. So a husband left everything to his wife, and the words were, to be at her disposal in any way she might think fit, best, for benefit of herself and family. In full confidence, sorry, I'm just reading the wrong passage. In full confidence that she will make use of it as I should have made myself, and that at her death she will devise it to such one or more of my nieces as she may think fit, and if she fails to do so, to be divided equally between my nieces. So I'll just read that again. In full confidence that she will make such use of it as I shall have made myself, and that at her death she will devise it to such one or more of my nieces as she may think fit, and if she fails to do so, it to be divided equally between my nieces. Now, in that, in Komsky and Bowring Hanbury, what the court said was that did create a trust relationship. So although the words in full confidence were used, at the end of the day, if the wife made no decision and didn't do anything, then the asset was to be divided equally between the nieces. So there was an imperative instruction. Yep. And this, really what you're looking at is whether what the settlor is doing, and normally a testator in these sorts of situations, is, are they creating a legal obligation that is a recognisable trust, so indicating that intention that that's what they want to happen, or is it just a moral obligation that is not legally enforceable? So this came up in a case called Pascoe and Boench, which is an Australian decision. It's just an example of the type of thing you might come across now. In that case, there was a husband and a wife, and they separated. Well, actually, no, they weren't married, they were de facto. And they separated, and they had 2 children. Now, the husband carried on living in the house, and but he was concerned, he started another relationship, and he was concerned to make sure that whatever happened, the house went to the children. So he didn't have a lot of money, and so he had a neighbour who was, he believed had more expertise than he did. And the neighbour drafted a memorandum. And the memorandum basically said that the settlor would get detailed trust documentation professionally drafted to best protect his children when he could. But basically what he was, the intention was that the house was to be held for the benefit of the, to make sure that it went to the children. And unsurprisingly, well, what happened was that the husband became insolvent, and so a trustee in bankruptcy, or the equivalent of a trustee in bankruptcy, was appointed. And the argument was, well, who owns this house? Has the husband validly put it in trust for the benefit of the children, using this informal memorandum that was drafted by the neighbour, or is that a valid trust in itself, or is that just a wish or a hope? Now, the argument for it being a wish or a hope was the fact that the documentation itself said, at some point professional drafting will take place. But the courts looked at the whole thing overall and basically looked at the wording and said, look, we think the memorandum is a valid declaration. He was making it clear that he wanted his children to have this house, not him. So they said they were prepared to treat it as a valid declaration showing an intention to create a trust. And the way they dealt with the provision that said, professional drafter will be used later, is to say, well, I think we can use that as an intention to resettle. So you can resettle trusts. You have a trust set up and you can put a power in a trust, or there's also some ability under case law to resettle it on different terms. So they said, well, we'll interpret that as being an intention to resettle on terms that might be more advantageous than the very basic sort of obligations that are set up in this informal document. Okay? So just remember that when you're looking at, you can have words like in full confidence. By themselves, they're precatory, a wish or a hope. But if they're tied to some sort of mechanism that enables a division to take place, then you could rely on Komsky and Bauer and Hanbury to say, well, actually, even though these words are a bit flaky, there was an intention that this was going to be held by somebody else. Okay. What the courts will do is construe words. Normally they're going to look at the words on the document declaring the trust. Now, often you'll have a document, sometimes you won't, you'll just have oral, something oral. Because for certain assets you can, but also the courts can look at conduct. And quite often you get these unusual cases where trusts can be recognised through conduct. So the famous one is this case of Paul and Constance. It was an English case. It was a case where a man was married and split up from his wife but never got divorced, and he cohabited with another woman. And they were together for a very long period of time. But he actually suffered, I think it was a work-related accident, and he got compensation during the time he was in his de facto relationship. And he was advised by a lawyer acting for him to put the money into a separate bank account from his de facto partner, which he did. But then they stayed together for years. Money came in and out of the account, and he said to her, this money is, of the compensation, this money is as much yours as mine. So anyway, time passed, he died, and then never having got a divorce, he didn't have a will, so his wife pops up saying, I'm the wife, under the equivalent of the Administration Act, I'm entitled to, effectively the money, to which the de facto wife, people acting for her, said, no, during his lifetime he declared a valid trust over this asset. He said the words, this money is as much mine as yours, so that creates at least a trust interest in half the asset for her. If he said, you treat it as a declaration that he's declaring a trust and the beneficiaries of the trust are going to be him and his de facto partner. So the courts looked at it and said, well, look, this is an unsophisticated couple. They wouldn't have known that this, to necessarily have gone and got legal advice on it, but it is clear that when he said those words, that what he was intending was that this was going to be an asset that was placed in trust. So they were prepared to treat the money in the account as being subject to a trust. So as it turned out, the de facto's interest was just a half interest, and the other half went to the first, the wife and children of the first marriage, but at least the de facto wife got half. Yeah? So you see similar sorts of things too, where sometimes you have, you pay for advance for tickets, or this case involves a club, a sort of a Christmas club. So or mail order actually, sorry, it was mail order. You put your money in and you order something from a catalogue, or here, I think this is involving air tickets or tickets to an air show. So if money is placed into a separate bank account, so you send your money in, to buy something, tickets or something else, and it's placed into a separate bank account, you can argue that the relationship you have with the seller of the services or whatever is a trust relationship. So that's what happened in this case. Money was sent in to a mail order company. It was banked into separate bank accounts for the purchasers. And then once the item was sent out from the factory or wherever it was, storage facility, then the money was transferred into the accounts of the seller. The seller went into liquidation. So the issue was, well, there were all these individual bank accounts. Did that money belong to the company, the seller, or did it belong to the people who'd purchased? So the court said, well, it's been placed into a separate bank account. That's an indicia that this is a trust relationship. We'll treat these as trusts. So that's an English decision. Morrison Kent and Commerce Commission is obviously a New Zealand decision. And that is a case regarding tickets for an air show. When people went to buy their tickets for this air show, they were put in into separate bank accounts, and the organisation basically went into liquidation before the show. So the issue was, could the creditors of the company take the money, or did the purchasers of the air tickets get them? And the court held that there was a trust. They said segregation of money into separate bank accounts is an indicia of a trust, so the purchasers got their money back, not treated as an asset of what would be the trustee, which was the company. Okay. If you got something like this, in an exam, if I said 10 million to AB in full confidence, she will remember my affection for my former employees, and I said to you, does that create a valid trust or not? The things I'd expect you to discuss would be the nature of the words that are used in full confidence. What is that? Is it mandatory and imperative, or is it precatory? Does it create a moral obligation or a legal obligation? Who are the intended beneficiaries? And is it clear that they're going to get specific things at the end? So here I would say no. So she might have spelt out who she might want to benefit, former employees, but she hasn't said what they're going to get, or he. So this just looks like a moral obligation. Now, normally, if you've got uncertainty of intention, so you don't know what is created, you're saying, is it a trust or is it just a gift? If it's in something like this, in a will, and you hold that this is just a moral obligation, then this will take as a gift, and AB will get the asset absolutely, but just subject to a moral obligation. If she wants, she can remember the affection for the employees, whatever that is, or ignore it. Is that right? Okay, so the next thing you need, so that's certainty of intention. Mandatory words, not precatory words. The second thing is you've got to define the subject matter, exactly what is going to go in trust. So this is emphasised in the Lehman litigation. A trust cannot be created without property to which it can attach. Where there is no property which is sufficiently identified to form the subject matter of a trust, no trust is created. So that means you've got to describe properly what is supposed to be in the trust. So there are two aspects to certainty of subject matter. And this only applies to, the second one only applies to fixed trusts. But basically, you've got to properly describe the subject matter of the trust. And if you don't do it, no trust is created. So words that are uncertain, or have been found to be uncertain, are things like bulk of my residual estate. Now, the problem with that is you don't know what the bulk is. Could be 70%, could be 80%, but if you can't tell, the law won't recognise the imposition of obligations on the trustee. The same, the remaining part of what is left. Or in New Zealand case, Mary to have a small part of what is left. Now what we do use in wills is the word residue. That's fine, because that has got a technical meaning. It basically means everything that's left in an estate after all the legacies and, you know, tax has been paid and creditors have been paid and all the gifts determined in the will have been paid out. The residue can be if there's anything left. So if you see residue, somebody to have the residue, that's fine.
So spraying and burn out the remaining part of what is left, doesn't that make up the residue?
Oh, there was more. Are we going to? Yeah, no. The remaining part of what it didn't work basically in that. Yeah, for various reasons in that case. I know it looks a bit like residue, but it sort of didn't work on the facts. Okay. Oh, it's residue certain. Yeah, I don't know what that came in there. Anyway, no. So the two aspects to, as I say, to property. First of all, for just discretionary trust, you've got to say what property is subject to the trust. But if you have a fixed trust, what you have to do is also say what property is subject to the trust, but also say what each beneficiary is going to get. So the beneficial entitlements for each beneficiary. Now, the main cases that deal with this are Re London Wine and Hunter and Moss, and there's also a New Zealand decision, Goldcorp. So just to give you an example of how peculiar often these rules come about when there's some sort of insolvency. So Re London Wine is a case where a company was running a business where they basically offer investors the ability to buy wine, and under this, sort of arrangement, purchasers would put their money in, they'd say they want to buy certain wine, and the seller would agreed basically to store it and to insure it. And deliver it. I think they agreed to deliver it, on certain notice. And in fact, in Re London Wine, the purchasers got a certificate of title, or certainly a certificate, saying they were the beneficial owners of certain wine. So they believed that their wine was held on trust by the seller. So the seller basically got into financial difficulty, became insolvent. So then you had a liquidator come in, and the liquidator looked at the wine and said, "This is a company asset." And the people who had purchased it said, "No, it's not. It belongs to us in equity because, look, we've got the certificate of title, and the certificate of title says that we're the beneficial owners of this asset." But the problem with that argument was that if you're going to have a valid trust, what you need to have is certainty of subject matter. So each of those purchasers needed to be able to point to the specific bottle of wine that they said was the trust asset. And in that case, there'd been no division of the wine. It was all just bulk, stored in bulk. Now, wine obviously is something the quality of which can differ depending on the bottle, because you can get corked bottles or good bottles. You can have one vintage or, non-vintage or vintage, or, all sorts of different wine. So basically the court said there is no trust created because the subject matter of the trust is not clear. You cannot tell for each trust which are the bottles of wine that were held in trust for that particular beneficiary.
Okay, so we're saying that individual trusts for every
purchaser. Yep.
but it was held in bulk.
Yes, yes. So we might have had a dozen bottles of wine, and all of us would have, some of us would have bought one bottle and, and another two. So we're saying, well, I'm the beneficial owner of one bottle in that box of 12, but I can't tell which bottle is my bottle. And so, unless you can be specific, and the case is not wholly clear on exactly what needed to be done, but they just said this is not specific enough to tell which bottles of wine are subject to the trust. So what you would need to do, which would have been easy, would have been to label them. Yeah? So you could have labelled them, or I suppose segregated. Had a number of ways you could practically have done it. So that meant that the purchasers did not have any equitable ownership in the bottles of wine. The assets were treated as assets of the company and available to all the unsecured creditors of the London Wine Company. And that meant that the purchasers were treated as part of those unsecured creditors. So they lost the benefit of that asset partitioning because there was not certainty of the subject matter. What was the asset subject to the trust? Now, that rule was slightly changed in Hunter and Moss. So there's two decisions, the High Court decision and the Court of Appeal decision, and that was a case which dealt with shares. So in that case, basically it was a medium-sized business and a man running a business, and he had awarded his CEO 5% of the issued shares in the company as a bonus for having performed well. And he decided to give his CFO, so Chief Financial Officer, the same thing. So he basically said, you can have 5% of the shareholding. Now, they had then had a falling out, so that the CFO believed that he had an equitable interest in these shares, which remained in the name of the original owner. They had a falling out, and the CFO demanded that the shares be transferred to him. He said, I'm an owner in equity, transfer them to me fully. So the argument for the original owner was that this did not amount to a valid trust, that the description of 5% of 950 shares was not sufficiently certain, because you'd actually, in those days, you would have a certificate of title, and actually the share certificates were all numbered. He said if you wanted there to be a trust over these shares, you should have set out the name and the number and of the share certificates, so we know which shares are yours. So the CFO challenged that. It went to the Court of Appeal. So Colin Rimmer QC, sitting as a High Court judge, he said, look, we need to treat shares differently. And he said, these are intangible assets. Each of these shares is exactly the same. So he said they're indistinguishable one from the other. They're all the same class. So he said it doesn't matter in this case. There's no need to segregate. There's no chance of any change. All these shares, these 950 shares, carry exactly the same rights. So he said in that case, they were prepared to loosen the rule and of certainty of subject matter, and they said that's fine. Now, it was appealed to the Court of Appeal, Hunter and Moss, and the Court of Appeal agreed, said the decision was right. But they did not rely on the tangible intangible. And I think that's right, because just because you've got an intangible asset, it doesn't actually mean that they're all the same. So that's not a valid way to differentiate what the rule should be, because you can have tangible assets that are all the same, can't you? Yeah, you could. Like gold ingots. They're assayed and done to have a particular value. So that's not a legitimate thing. So they said, oh, no, they just disregarded tangible and intangible. They said, look, have a look and see if these things are all indistinguishable one from the other. And these are. So you don't need to segregate. Okay, so that was a rule that was loosened for a particular type of shows in action, shares. And that case was actually followed as well in a case called Re Harvard Securities, which is again a case regarding, it was a case where sort of a broker held a whole lot of shares on behalf of a number of clients and then went into liquidation. So the same sort of thing. Now,
It applied to other assets other than shares?
well, I put up a couple, these are the basic cases, there's a number of cases on it, on these sort of things. And there are, there are some funny old rules. Depends on if your assets are fungible or not. But that main principle, the law hasn't developed that much. There is a case in Australia called White and Shortall, which attempts to resolve all issues resolving.
Isn't the Gold Corp one similar? Because they couldn't point to the particular gold bars, so they said no, but if they're indistinguishable.
Yes, that's right.
argue
Yeah,
that.
well, that was slightly different.
They weren't.
That was a really interesting case, and they because in Gold Corp, the argument was had they created a trust at all, and the issue is what was the nature of the asset that they entered into, and I think didn't they decide? I'm just trying to think. They decided that it was.